Good evening, everyone. My name is John Osa. It's my pleasure to be the moderator of this session. Would ask Marcus if you could begin your presentation.
So, thank you very much, John, and good afternoon, everybody. Good afternoon, AIPPI members. It's a great pleasure for me to have this opportunity to speak on behalf of the brand and design sector of WIPO and to give you a brief overview on current issues in the area of progressive norm setting in brands and designs. The emphasis will be on brief because there's quite a good number of issues and I've been given 15 minutes. So my presentation, unfortunately, will not be able to go much beyond a listing of those issues with the relevant references, but the references should enable all of the participants of this webinar maybe to then follow up themselves and maybe read up on those areas and issues which are of particular importance to them. Let me just share my screen here and then let's start. Okay. So the work in the area of what we refer progressive norm setting or progressive norm development as far as brands and designs are concerned is taking place in a technical committee that has been set up to that effect, namely the WIPO Standing Committee on the Law of Trademarks, Industrial Designs and Geographical Indications that should have held its 43rd session about a month ago. But unfortunately, due to the circumstances we all are aware of, that didn't take place. The SCT, as you can see, was created in '98, and like the SCP for patents or the SCCR for copyright, it's intended to be a forum to discuss issues and to facilitate the coordination among our member states in the area of norm development on international law. And as far as the SCT is concerned, it's about trademarks, industrial designs, and geographical indications. And to give you a better idea of what's currently going on, I thought I'd just run you briefly through the agenda of SCT 43, which, as I said, unfortunately couldn't take place. And I will break down that presentations into the various subject matters, namely trademarks, industrial designs, and geographical indications. So I'm going to do it over 15 minutes, and then my colleagues, Grégoire and Debbie, will follow up with more specific information concerning the various registration systems that correspond to designs, namely the Hague System, and to trademarks, the Madrid system. And I myself will say a couple of words to the Lisbon system that is an international registration system protecting geographical indications. So as regards industrial designs, the SCT has been working for quite some time on a new draft international instrument, draft design law treaty, which is intended to become an international treaty along the lines of what we already know in the area of trademarks for the Singapore Treaty on the Law of Trademarks, or in the area of patents, the Patent Law Treaty. So it is a draft instrument that sets up certain harmonized and in particular simplified rules for the registration and management of industrial design through design registration systems or design patent systems, as the case may be. Now, the industrial design, the draft design law treaty has been more or less ready at a technical level, but there are a couple of issues that's holding it up to be sent to a diplomatic conference, and this is being currently discussed by the WIPO General Assembly, who will revert to that matter in its meeting in next September, and hopefully we'll be able to achieve an agreement and find solution to what is outstanding. So again, in the interest of time, I won't be able to give you more sort of detail of what really is holding up. It's quite a complex issue, but I'm more than happy to follow up either bilaterally or, in another forum organized by AIPPI on that matter. And I should say, by the way, AIPPI obviously as an observer organization is following our meetings and is also accredited to follow the SCT discussion. So one area that is important to AIPPI understand, because there's also a dedicated resolution, is the protection of graphic user interface designs, or Gooeys. And there are a number of issues that came up when it comes to GUI protection or icon or typeface, type font design protection. And the Standing Committee has been working in that area for quite some time. It has run a number of surveys amongst its members, so to get a better understanding of how these designs are being protected and what, if anything at all, stands in the way between more efficient protection of Gooey designs in particular. So here I would like to refer you to the questionnaire and analysis that is being presented in document SCT 41.2 Ref, and in particular 43.2, which was supposed to be presented in March, but we couldn't, which is a very interesting document that presents an analysis of GUI protection in our member states. Those members that have responded in particular point out whether they protect GUI designs via a design patent system or via a registered industrial design protection system. And following on then, there are a number of more specific questions, particularly tailored to design patent systems, in particular, such as the necessity to link your GUI design to a physical article, which apparently in the past has caused some problems. And there's also a proposal out there by the delegations of the United States of America and Japan that addresses some potential shortcomings of design protection for GUIs. It's presented in 42.6, and it aims at an international declaration or recommendation rather by the WIPO General Assembly that would clarify certain matters relating to GUI protection, such as in particular that famous link between the physical product and the graphic user interface. Now, this is all very, very abstract for those in particular who haven't looked into it, but I mean, Ken mentioned before the issue of patent protection for smartphones or mobile phones, and obviously today's mobile phone is no longer a telephone. No, it's a handheld IT device that enables us to do many, many things. Least of all is probably making telephone conversations. And all of that is being operated through graphic user interfaces. And here, if you go down the design patent road, you know, you have to identify, no, your interface, is that for a camera, for a dictaphone, for a GPS, for a communication device. You know, you have potentially hundreds of different apps on your mobile phone that really go far beyond a simple description as a handheld device. So you can see a little bit the challenges that are here, and we're trying to address those issues at the SCT. A bit unrelated to GUI designs, but yet of importance, is the question of temporary protection for industrial designs under Article 11 Paris Convention, one of the oldest and you could say most ancient provisions within the Paris Convention. One of the reasons why the Paris Convention back in 1883 actually was negotiated and adopted, namely to provide temporary protection for certain inventions, designs, trademarks, etc., shown at international exhibitions. And you know, the question of how this provision is being implemented with regard to industrial designs by our member states and the contracting parties to the Paris Convention is an open question. And again, we run a survey among member states. How do you provide your temporary protection industrial designs under Article 11 Paris Convention? And in particular, what constitutes an international exhibition that would qualify under your national law for the application of Article 11? So all that has been, the information has been collected, it's presented in 42.2, and the plan actually was to hold a half-day information session as an integral part of the SCT meeting to present the findings of the survey and to have users and patent offices present their particular views on that issue. Now, unfortunately, that information session had to be postponed as it be, and we hope we will be able to very soon come up and with a solution to that and present the information session and see whether there is some area for further development of the application of Article 11 of the Paris Convention. So time's running, and so am I. Going on to trademarks, and here a topic that has been discussed for quite some time is the protection of country names and geographical names of national significance. And if you talk about protection, it's negative protection, namely against the unauthorized or unlawful registration or use as trademarks. So the idea here is no is there something that ought to be done to prevent individual parties from registering and obtaining exclusive rights in trademarks that consist of country names? And here we have a brand new proposal by a group of countries, and I listed the countries here. I'm going to read them out. And that again was supposed to be presented at SCT 43. Unfortunately, it couldn't take place. The proposal actually puts forward an initiative to say we want to propose that the WIPO General Assembly adopts a recommendation for an examination guideline for trademark officers, under which applications for certain types of trademarks consisting of country names should be rejected. It's a nutshell, obviously, an explanation in a nutshell, so it's more nuanced and more detailed. And those of you who are interested, please refer to document 43.6. It's all available online. And then there's a second, if you like, layer to this debate on protection of country names, and that is the protection of country names and names of a certain geographical significance, not against unauthorized registration of trademarks, but within the domain name system, in other words, as a delegation as top-level domains or second-level domains. And this is a work that interfaces very tightly with work that's going on within ICANN and the Government Advisory Commission of ICANN. And again, a certain number of countries, here they are, have proposed that WIPO should issue a recommendation to ICANN. And that recommendation, the delegation of certain country names as generic top-level domains should be prevented. This is work in progress. There are different views on that proposal. It's not unanimously supported, and again was supposed to be discussed at the SCT's last session. And finally, the SCT is also considering a new initiative which is being based on the proposal by the delegation of Peru, and it deals with the protection of nation brands, and that obviously is a very interesting issue because nation brands are not defined really internationally. So the question is, what are nation brands? How are they being used? And is existing IP protection for nation brands sufficient or not? And what's happening as in with the other projects, before we can engage in some further discussion, let's do some fact finding. And we've just been working on a survey, which will be out hopefully soon, under which we will try to collect information that will enable the SCT at its next session to better consider that proposal and to see whether there is a need for example, international definition of nation brands and scope of protection, or whether indeed the existing IP system, in particular trademark protection, unfair competition, etc., is sufficient for nation brand protection. Okay, in a nutshell, that's trademarks. I'm running and moving on to geographic indications. Now, geographic indications is a very emotional topic, and many of you will be aware that there are different approaches to the protection of geographic indications. And in 2015, an international diplomatic conference took place here in Geneva that led to the adoption of a new act to the Lisbon Agreement for the protection of geographic indications. I mean, to be very precise, the existing Lisbon Agreement is called the 1958 Lisbon Agreement for the protection of appellations of origin and their international registrations, and that was revised through the Geneva Act now for the Geneva Act of the Lisbon Agreement for the protection of geographic indications and appellations of origin. I'll come back to that in a minute. Now, aside from the work on the Geneva Act or the Lisbon Agreement, the Standing Committee has continuously been engaged in exchanging information and views on protection of geographic indications, and that is being reflected in particular in two quick questionnaires that were run and resulted in surveys that helped us to collect information on geographic indication protection at the national level. And here I really would very strongly advise you, those of you who are interested in geographic indication protection, to have a look at the geographic indication database that we created based on the returns to those two surveys, which is a very, very complete collection of very specific national and regional data relating to the protection of geographic indications, such as we know, for wines, spirits, cheeses, etc., but not not certain regional specialities as are being protected under the system of the European Union in particular. So questionnaires, results, and we have this database, and I put the link here on my slide, which is a very, very useful resource for those of you who want to research in more detail the question of GI protection at the national level. So I mentioned the Lisbon Agreement, and or before I go there, I also should have said that the Standing Committee on the Law of Trademarks, Industrial Designs and Geographical Indications, the SCT, has identified a way also to engage in an informal exchange of views and information concerning geographic indications, and this is being done in the form of informal information sessions that are being held back to back with the SCT. And there was one scheduled also for March, and that information session was supposed to consider two issues, namely the conditions that created the basis for geographic indication protection in the first place and how to evaluate the change of such conditions. It's a very, very technical matter, but what really is behind is the famous link between, on the one hand, your GI, and on the other hand, your area of production. And if you notice that over time, the area of production for specific GIs will grow, the question is, what are the specific conditions under which the extension of these production areas can be reviewed, evaluated, and judged? And is it really okay that if you say my product has a specific quality that is due to its origin in a particular area, that area over time doubles or triples in its size? So this underlies a little bit that debate. And then there's a second debate on what are the ways to prevent operators from bad faith registration of geographic indications domain names. So in other words, we have a system to challenge bad faith domain name registrations that use trademarks, namely the famous UDRP, but that UDRP is limited, as we all know, to trademarks. And the question is, shouldn't that be extended to, for example, geographic indications? It's a long-standing debate, various views, and there was supposed to take place this information session to shed some light on that. I hear John, I think I have another 3 minutes, John, correct?
Yeah.
Okay.
Oh, you have a minute at this point, and please try to stay
Okay.
close to the microphone because you're fading in and out a bit.
Sorry, yeah, it's my headset. Now what I thought would be very interesting, just to sort of round this up, is to give you an idea of how many GIs there are around the world, because we spent a lot of time on GI debates in the SCT, in the Lisbon Union, in the World Trade Organization, among other areas, bilaterally. But it's quite revealing that there are not that many GIs really, and this is an excerpt from our annual IP statistics, and you will see that there are not much more than about 65,000 GIs around the world that are being protected. So it's a relatively limited number if you compare that to the 14 million trademark applications we saw in 2019. And most of those GIs are, not most, but a good portion of those GIs are being protected by wines and spirits, agricultural foodstuffs, and a small portion for other products. And you see that within Lisbon, there is still a very, very discrete number of appellation of origin registered, some thousand, with France being the champion, holding about half of them. So the 2015 Geneva Act, and this is my last 2 minutes here, entered, and I think it's important to note, entered into force this year on February 26. It entered into force with the ratification of 5 contracting parties, namely Albania, Cambodia, the Democratic People's Republic of Korea, Samoa, and most importantly, the EU as an intergovernmental organization. So all 27 EU member states are now integral part of the Lisbon Agreement. And under this Geneva Act, we saw a broadening of the subject matter scope, so protection not only for appellations of origin, but for appellation of origins and geographic indications, explicit safeguard for prior rights and generic terms, which is a very, very important point, and also very strict due process provisions that apply to newly registered GIs. This concludes what must have been the fastest ever presentation of a SCT agenda. So thank you very much for bearing with me. And in case there are some questions available, obviously, and would be very happy to entertain those. And back to you, John.
Marcus, thank you very much for that whirlwind tour. We could have spent an hour or more on that easily, so great job in collapsing that into 15 minutes. We're going to have all three of the speakers under the brands and design sectors speak, and then we'll take the questions at the end. So Grégoire, the floor is yours.
Thank you very much, John, and good morning to you, John. Good afternoon to everyone. Good evening to some of you. Let me perhaps start by extending a special greeting to the members of the AIPPI Turkey, because I was scheduled to speak at an AIPPI Turkey design event some 2 weeks ago, but that unfortunately had to be postponed for obvious reasons. So special greetings to the folks there. Let me perhaps switch on to my presentation. Here we go. I intend to be relatively compact today. So bear with me as I race through my slides. I just want to provide the audience with a quick update on the Hague System. I will be saying a few words about 2019, then I'll move on about the geographical expansion of the Hague System, and then I'll be saying a few words about the ongoing developments. So first, 2019, facts and figures. It was a very good year, 2019, for a number of reasons. First, we started the year with an important rule change that made the appointment of representative easier. In a nutshell, when a representative files an application, it is sufficient that that representative signs the form without attaching a power of attorney. And since we've introduced that rule change on January 1st of last year, we saw a major drop in the number of irregularity letters that we needed to issue. So that was indeed a very much welcome amendment. In terms of filing, at the end of the year, we observed that we had quite a successful year with a 10% increase in designs filed with us, and a new record indeed, or close to 22,000 designs had been filed under the Hague System. Where were these designs coming from, and for which classes? Well, we saw there some interesting new trends. Classes 14, 6, and 12 were the top 3 classes in 2019. Now, class 14 is the one that bears the antiquated label of recording and communication equipment. Since the turn of the millennium, it was mostly used for mobile phones, and as we saw more recently, it's mostly used for Gooeys that Marcus mentioned earlier on. So it's quite a fast-growing area under the Hague System as well. Class 6 is, of course, furniture, and that is largely driven by solid usage in Europe. And class 12 is for vehicles, and that is still largely driven by solid usage in Europe, and apparently strong growth from France, but as well from Korea. And that allows me to move to the geographical sources of those filings in 2019. And whilst most of the design, or whilst the top origin still was Germany, and it's been the case for years on, the countries from which we saw the strongest growth were China, Korea, Italy, and the UK. There was a slight decrease in the US and as well from Japan. But what we've noticed with great satisfaction in respect of both the USA and Japan is that whilst the numbers were lower in 2019 than in 2018, we've seemed to have expanded the user base. So in other words, we received slightly less designs from these jurisdictions, but they were coming from a wider number of individual applicants. Also, the very good news regarding 2019 is that refusals were down whilst grants of protection were up. And that shows that, you know, the system really is working, and particularly we have had more and more what we call success stories. What we mean by that is applications designating various examining jurisdictions, so jurisdictions where the design office would be carrying out a substantive examination and a novelty examination of the designs filed, and we saw a growing number of cases that have passed muster with all the offices. So I think that's an important message, because initially when examining jurisdictions started joining the system, and that's a fairly recent phenomenon, with the First Republic of Korea joining in 2014, and then the USA and Japan, and more recently Canada, Russian Federation. And there was strong skepticism as to whether the system would indeed allow someone to cover all these territories with success. And so the proof is in the pudding. We have a growing number of cases that do designate a series of such jurisdictions and that receive grants of protection from these jurisdictions. And the example I've shared on the slide here is probably our champion. This application designated 35 jurisdictions and received grants of protection from 34 jurisdictions, including Japan and Korea. This is, folks, the world according to the Hague System. So it's not everything that you see in blue is currently Hague coverage under the Geneva Act of 1999, and it's not as widespread as the Madrid system, let alone the PCT, but it's a fast-growing system. We currently have 74 current parties to the Hague System, and which represents 89 national jurisdictions being covered. And everywhere where you see the checker pattern of white and blue are jurisdictions where there are concrete legislative and diplomatic steps undertaken towards acceding. So the slide is, the map is a bit busy. Some of these countries are admittedly small, so let me perhaps run you to a list in terms of recent accessions. And what I mean by recent is really those that came into force in the last 2 years, or that will come into force very soon. You see that we've included Canada recently, but those that you see in blue, Israel, Mexico, Samoa, and Vietnam, are more precisely countries that just joined this year. In the case of Mexico, the accession will become effective on June 6 this year, so it's not there yet. But with the addition of Canada and of course the presence of the USA, that means that we've got the whole North American territory covered. Also important in the Brexit context is the fact that the UK has joined almost 2 years ago, and Vietnam was also a long expected accession. Now moving to the list on the right, if I may, these are potential accessions for the next couple of years, or 2020 and 2021. Obviously, some of these countries are small jurisdictions, small markets, but other are large and very large indeed. China, last time we had an exchange with our interlocutors from China, they gave us the indication that they were expecting the instrument of accession to be deposited in the second quarter of 2020. Now, of course, given the current circumstances, we understand that the government probably had to put this important file on the back burner, but we expect China to join this year nonetheless. Additionally, other large markets are Kazakhstan, Indonesia, very important market, especially for users in Japan and Korea. There are more countries considering joining, but we do not expect them to join in this horizon of time. Now, about ongoing developments, if I may. Well, first, very recently, in January of this year, we made it possible for Hague applications or for your Hague applications to be uploaded in the digital access service. I think it bears recalling, John, that the contrary to the PCT, contrary to the Madrid system, the Hague system is very much used as a first filing system, and that is indeed the best way to use the system, is to not designate not file locally in your home jurisdiction, but designate your home jurisdiction alongside the export markets. So a lot of folks are using the Hague system in that way, but then if should you want to go outside of the Hague system and claim priority from your Hague application, you can do that, and by allowing you to upload your Hague application into DAS, we're making it easier for you to claim priority in those non-Hague jurisdictions. This year also we resume talks with the UK IPO concerning what would happen to your titles under the Hague system at the end of the transition period, which is still currently planned for December 31st of this year. We're working together with UK IPO towards ensuring that we can do this in the most favorable way for users. Now, we will be holding the General Assemblies of WIPO in September, hopefully. There's a number of important topics for adoption by the Hague Union Assembly in particular. One is yet another important rule change, that this one concerns changes in ownership. We again want here to lower the threshold of formalities, and particularly the proposal is that it would be sufficient for the request for the recording of a change in ownership to be accompanied by an assignment document if it is signed not by the assigner but rather by the assignee. And if that amendment is adopted, then it should come into force on January 1st, 2021. There's also a proposal to hike up the fee for additional designs. Currently, that fee is very, very small. It's 19 Swiss francs. It has been the case since 1996, I think. So it's high time it be reviewed. So we got the blessing of the Hague Working Group towards making a proposal for that fee to be increased to 50 Swiss francs. It seems like quite a jump, but in fact, when you're putting that in the global picture of the fees and associated agent fees concerned, we're really talking about a very, very small increase indeed. And again, that should it be adopted by the Assembly, should come into force on January 1st, 2021. There's also a proposal for a new provision that would allow an applicant to add a priority claim after filing the Hague application. This is based on a similar provision under the PCT, and it should come into force not on January 1st, but at a later date to be confirmed. Now, we also have a working group for the legal development of the Hague system, very much like the PCT, as Ken mentioned. Currently, the session is planned, it's still planned for December 14 to 16. I think it's important that AIPPI be represented. It had been the case in the past. It wasn't the case at the last session that we held, unfortunately, and I urge AIPPI to send representation there. I know the AIPPI design team is extremely strong. You have leaders there, and would be extremely useful if you could be represented there again. The topics for consideration for the working group are the language regime. We're under pressure to expand that. An ongoing fee review. We're also under pressure by member states to revisit our fees in general. And perhaps the last point, which is the most important, is a standard publication time. Currently, it's 6 months. So as you know, in those jurisdictions where they do not allow you to defer your application, you can still benefit from standard publication, which would happen 6 months after your date of registration. The objective was to put you in the same shoes that if you had filed domestically. With experience, it appears that this standard period of 6 months is too short. At the last session of the working group, we had proposed to extend it to 12 months. There was major backing from all offices and from the 4 user groups involved, but there was resistance from one office, and that office required that we further consult the NGOs about this to make sure that the whole IP community was in favor of this. So we intend to do this through consultations that will be launched later this year in the spring or summer. But again, it's important that the AIPPI make its voice heard in that context. My last slide, in those difficult times, how can you reach us? But first, let me rebound on what Ken said. We're fully operational. We have examiners. All examiners are looking at your applications from home and processing them as normal. Should you need to get back to us, however, do not use the telephone line, but use the Contact Hague link that you see on our Hague page. And you can also use that with a view to submitting document to us. There's an upload document feature there that you should be using. Do not use standard mail, please, as these are no longer operational. That was my last slide. Sorry for running through this, but questions will be welcome during the during the question session. Thank you very much for your attention. Back to you, John, if I may.
Grégoire, thank you very much for that exhaustive and informative tour of the Hague system. And thank you also for the invitation to participate in the working group. We certainly do intend to be there in December. So thank you for that. And Debbie, you now have the floor.
Thank you, John. And good afternoon, ladies and gentlemen. It is my pleasure to give you the latest update on what has happened in the Madrid system. Let's see if I can get this running. So currently we have 106 contracting parties. These contracting parties cover 122 countries. And the reason why these numbers don't match is that we have 2 intergovernmental organizations as members, the EU and the AIPPI, and all their members are not individual members of the Madrid system. We had a very good year last year with 3 major countries exceeding the system. And these are Brazil, Canada, and Malaysia. This is what the current map of the Madrid members look like. We don't really have as many colored countries as the PCT, but eventually we hope to. So the countries marked in red indicate their members. So you can see that we need more members, need more colors in Latin America, in Africa, in Asia, and in the Arabic region. And this is coming. We are currently working with more than 20 countries that find themselves in the various stages of preparing for future accessions. Some of these are now at quite advanced levels, and we expect that a number of the countries will join within the next 1, 2, or 3 years. And the countries that we believe are the closest to accessions would be South Africa. That would be a big market for many trademark owners. In the Arabic region, we're working with Saudi Arabia and United Arab Emirates. In Asia, we're working with Bangladesh, Pakistan, and Sri Lanka. Malta has indicated that they will join the Madrid system this year, but they won't necessarily have much impact since they're already covered by the EU as a member. And in the Caribbean, we are working with Trinidad and Tobago. So hopefully this map will be looking a little bit different within the next few years. These are the newly released statistics. We had an exceptional good year last year, another record year for the Madrid system with more than 64,000 international applications coming in. Among our top filers, we have L'Oréal with 189 applications, followed by Novartis and Huawei. And for the first time, we have applicants from China and India on our top 5 list of applicants. Looking at where these applicants come from, this is based on the address of the applicant. Most of our applicants come from the US, followed by Germany and China. And then later France, Switzerland, UK, Japan, Italy, and Australia and Turkey. So these are the top 10 countries based on the address of the applicant. If we're looking at where do they seek protection, this is the other side of the coin. This is the list of the top 10 designated contracting parties. And on top of the list, we have the EU, followed by China, US, Japan, Russian Federation, Australia, Switzerland, UK, Republic of Korea, and India. And on this list, the UK is the only European country that is individually on the list that are also members of the EU. And this is because of the Brexit. They have been designated quite a lot in recent years. Looking at the latest developments, we had some minor legal changes that entered into force on February 1st this year. The common regulations have now changed name to regulations under the protocol. And this is to reflect the fact that the protocol is the sole governing treaty of the Madrid system. So we have taken out common and all references to the agreement. Brexit has happened. As my colleague Grégoire mentioned, the transitional period is until December 31st, 2020. The withdrawal agreement between the EU and the UK covers what happens with CTM rights. And we, the Madrid system, as along with the Hague Registry, are discussing with the UK on what will happen with international registrations covering designations of the EU. We have information on our website concerning Brexit and some frequently asked questions. So if you're looking into more on this, please visit our website. We are currently scheduled to have our Madrid working group meeting in June this year. It has not been confirmed, but we're still planning ahead. We have some interesting topics on the agenda for this year. We have some proposed amendments to the common regulations. One important one will be to make it mandatory to provide an email address when you fill out an international application or a request for a change. This will allow us to have a full electronic communication with our users. We will be discussing replacement in the context of allowing for partial replacement. We will have discussion paper on provisional refusals, where we look into some of the challenges that users are facing today with time limits to respond to provisional refusals being set by the various offices in line with the domestic legislation. And also that officers calculate the starting point of the time limits differently, and this causes a lot of problems for the users. So we're looking into this. We also have a discussion paper on dependency, the 5-year dependency period. We are, as the Madrid and the Hague system is also discussing, the possible introduction of new languages to the Madrid system. We currently have English, French, and Spanish, and there is a proposal on the table to introduce Arabic, Chinese, and Russian as well. If you want to learn more about these issues, visit our website, and as soon as the documents are ready, we will publish them on our website. Then coming back to COVID-19, and this will be to supplement what my colleagues Ken and Grégoire has talked about as well. We have suspended the postal service for WIPO, so WIPO is not currently able to neither receive nor send communications to our users via postal mail. So we have to rely on electronic communication. So if you have not yet provided WIPO your email address so we can communicate with you, please do this as soon as possible. This is very important. I cannot stress this enough. If you have an international registration and you have designated offices and you're waiting for their decision, they will have to send their decision, if it is a provisional refusal, through WIPO. And we will need to forward this to the holder. And if we cannot send this out through email, it will basically be put on hold for now. Some of these offices, as I mentioned, will calculate the time limits from when they send the refusal to WIPO. So it is important that you make sure that we have your email address so we can communicate with you when we receive decisions. We have published information on our website on time limits and possible relief measures if you are affected by COVID-19. We also have a dedicated Madrid webpage on this issue. And here we will put up all the information we receive from offices. We publish information notices from offices if they tell us that they're closed for the duration of the closure or if they're extending the time limits. So this is an important website to be aware of. If you need to provide us your email address, please use the Contact Madrid page. If you have questions, please use also this page to send us your questions. And I think this was rushing through the information, but at least you will have time for some questions now. Thank you.
Debbie, thank you very much for that update. I have one very practical question. Presumably you don't want everyone to submit their email address to you if you already have it. Is there a way to verify that you have, that our email address is correctly on file?
For users of International Madrid System, I think it's important to make sure that you have the Madrid Portfolio Manager, that you use our tool to manage your rights. And if you have that, you have provided your email address. But you can also see whether, if you have provided an email address in either an international application or a request for change, we will be using that to communicate with you. So if you if you don't receive postal communications from us, that would mean that you have to provide us an email address. And if you send a question through Contact Madrid, we will verify for you.
Okay, thank you very much. Then I have a question relating to Gooeys. Gooeys play an integral part in all of our daily lives. Yet from the user side, there's still considerable lack of clarity from jurisdiction to jurisdiction as to how to best protect Gooeys and under which form of IP rights. AIPPI passed a resolution in 2017 supporting protection of Gooeys under all of patents, trademarks, copyrights, and designs in appropriate circumstances. With respect to designs, AIPPI's resolution asserts that design protection should be possible without requiring connection to a physical device. And with respect to both trademarks and designs, the resolution asserted that movements and transitions should generally be capable of protection. Now, in light of what we've heard today about what's being done in SCT, could you comment on protection of Gooeys in general and specifically on these two issues of connection to a physical device and protection of movements and transitions? And I address that generally to anyone who would like to answer it.
Thanks, John. Well, let me jump in here, maybe to start out, and maybe Grégoire can then complement it from the point of view of the Hague system, which, as you've seen, provides for the practical steps for protecting Gooeys. The landscape is really diverse when it comes to Gooeys. That we have seen, and I think this is also being confirmed by the work of AIPPI. The good news is Gooeys are being protected, and our latest survey seems to confirm that. No? The difficulty, however, is that there are various ways of doing it, and even within the industrial design world or the realm of industrial design, we know very well that you have two different worlds. One is the design patent world, and the other one is the registered design world. And it seems that GUI design protection in the registered design world is a relatively straightforward matter. So there we don't have much of feedback or much comment on this area. It seems to be that there are more challenges when it comes to design patent protection for GUI designs, in particular when it comes to the connection to a physical device and the claims and also the representation and moving GUIs and all these sort of things. So I think the proposal by the delegations of the United States of America and Japan to the SCT and ultimately to the WIPO General Assembly shows a little bit the direction where this could move, namely to identify certain flexibilities, in particular in the design patent protection system, that would cater towards the protection of certain features of the GUI designs. In other words, to make it more accessible, quicker available, and more effective when it comes to the actual protection of those designs. So in essence, we have a rather fractured landscape. There's no one-size-fit-all approach. It is really very much country by country, and as we have seen, even trademark protection is an option, and why not under the competition of copyright as well. So as I said, the good news is the means are out there. The bad, or not so good news is that, you know, there's no common approach to the system throughout jurisdictions, but right owners might well have to, you know, find the best way to their GUI design protection in the jurisdiction concerned. But as far as design patent protection is concerned, there's work underway with a proposal by Japan and the US to the WIPO General Assembly, maybe to identify certain solutions that would provide more leeway for this type of protection. So this summarizes the situation, I think, as far as the SED is concerned.
John, with thanks
Thank
to
you.
Marcus, if I may help on this as well by giving the Hague perspective, I think indeed that this existence of a fractured landscape that Marcus aptly described encapsulate the best example of what would undermine the efficiency of the Hague system as an international procedural vehicle for getting protection. Indeed, it would be extremely unfortunate if users filing in various jurisdictions under the Hague system were to be met by different results from offices in respect of Gooeys. So I think it's very important that somehow at the substantive level there's some convergence as to what are, you know, the requirements for the protection of Gooeys as industrial designs. And perhaps I would also say that I think the situation globally is improving. Our observations are only empirical. As I mentioned, we do receive a growing number of Hague applications for Gooeys. In the past, such applicants tended to be extremely selective and careful in their choice of jurisdictions. So they would often designate only the EU and Switzerland and one of the examining jurisdictions, but not two or three. But the results have been, and again, it's an empirical observation, have been positive in the sense that even in that examining jurisdiction that they would have selected in the given case, there was a grant of protection. And lately, we've noticed that people were less shy and tended to designate more broadly. So hopefully they will be met equally with success. Because again, the Hague system is very permissive at this level. You can file for a GUI without showing the physical product. And that's perfectly fine by us according to our formal standards and requirements. But it's important also that, you know, substantively, it is also something that is recognized by the examining jurisdictions. So I think it's going in the right direction. Hence the importance of the work taking place in the FCT, hence the importance of the work taking place as well in the ID5, because this is an issue that the ID5 officers are discussing amongst themselves. They're fully aware of the importance of the issue. And I think it's also, it underscores the importance of your work, the IPPI. I think it's important, again, that your voices be heard. I don't think that Marcus and I have yet touched upon the second of the question, which are moving designs, you know, or evolving designs. And that's, again, a completely different game here. I know that 5-6 years ago in the Hague context, we made a proposal for allowing applicants to file moving files or moving designs. And there was a major pushback from offices because they said, we're not ready to grant protection to these. It was the conclusion was that it would be put back in the agenda of the Hague Working Group in the future. But again, I think that on such issues, you know, cutting edge issues, I think it's important that NGOs take the lead. You represent the IP community, you represent the users. If you think there's a need, there's a demand for this, it has to be heard. It has to be coming, you know, from the NGOs, the user groups, and that would probably, you know, give more confidence to our member states. That's all I wanted to say about this. Thank you.
Thank you very much, and we'll take that advice and continue the pressure on the moving designs point, and hope we can move forward on that in the future. I have a question here presented online from Nahid Abukas. I'm sorry if I got the name wrong, but it's very practical and timely. I think it's for you, Grégoire, again. Would epidemiological test strips be the potential subject of industrial designs?
I'm not sure exactly what such a strip is. I can imagine perhaps, but listen, my answer would be somewhat disappointing in the sense that under the Hague we will take whatever complies with the formal requirements. So to the extent that you're able to show something that is a product, and again it could be just, you know, an image. It doesn't have to be a physical project, but to the extent that you comply with our formal requirements, we would be taking your application and processing it and recording it, publishing it. I guess the real question is this something that is capable of protection under the different various substantive laws? And this, I don't have an answer to this, unfortunately.
Okay, thank you. Thank you very much. And we noted in the DG's latest report that the Global Designs database now has about 11 million records. That's a 50% increase over 2018. And the Global Brands database now has about 40 million records, which is a 40% increase over 2018. So that both seems great. I wonder, Grégoire and Debbie, if you could comment on that, and also specifically tell us about the AI-assisted image search tool, which I find to be absolutely amazing, but it seems like a lot of folks don't know it's there.
I would let perhaps Debbie take the lead, because that search tool is only available to for trademarks, aside from class 32 under Locarno, I think.
Yeah, I would advise users to take a look and test the global brand database, especially the new AI feature. It provides much better hits by using the different filters now to find marks that might be in conflict with your mark. For example, for clearance searches. It's difficult to show you from here, but there are different filters you can use, and the new filter would provide much better hits. So I would follow the tutorials on the website if I were you.
Okay, is that tutorial something that we could send perhaps a follow-up link to our participants in our membership? Because I
look at that when
I benefited. Yeah.
Yeah, I'll send you some information later.
Okay, that would be wonderful. Thank you very much, and thanks to all three of you for very informative and timely presentations. And thanks to all who submitted questions as well.